Oh, too late for my chest. Okay, good afternoon, everyone. Thank you all for being here. My name is Michelle Farrell. I'm the director of the International Law and Human Rights Unit, and this is the first of our speaker series events that is happening this academic year. I am really actually over the moon to welcome Professor Bill Schabas, Professor William Schabas, to the University of Liverpool and to the School of Law and Social Justice, and as our first speaker of the semester. Professor Bill Schabas, I've known now for 10 years?
At least.
At least. Which makes me start to feel old, but hey, I'm Professor Bill Schabas is a professor of international law at the University of Middlesex in London, an adjunct professor at the University of Leiden, in our Centre for Human Rights in Galway still, which is where I first encountered him. The microphone is turned on, isn't it? Bill Schabas sort of needs no introduction from an academic point of view. I think most of you in the room will, if you hadn't heard of him already, will have Googled him and seen that he's a prolific writer, in fact, a frighteningly prolific writer, has written monographs on subjects from the death penalty to genocide, to the International Criminal Court, to the International Criminal Tribunals, as well as the Travaux Préparatoires, which are really the handiest guides you could ever wish for if you're an international human rights lawyer, to both the Universal Declaration of Human Rights and the European Convention on Human Rights. And that's just some of the monograph work, not to mention the over 200 articles at this point. It must be well over 200 articles at this point. I remember the figure 180 from maybe 10 years ago. So it really, I've been pursuing Professor Schabas to come to Liverpool since I started here in September 2012. But he's a busy man, and on a couple of occasions we had a date set, and something would come up, something pretty important. So it really is, it's a happy moment for me to finally have gotten him here today, and he's going to speak today about the right to truth and whether there is a statutory limitation on the right to truth. So I think without further ado, if you would like to take the floor.
Okay. Well, thank you very much, Michelle. Is this all working, the technology, the sound, and all of that? Great. I promised Michelle I'd tell a little story before I started. And it's about a lecture I was at recently, late in the afternoon after people had a long, boozy lunch. And someone fell asleep in the audience and started to snore. And it was quite disruptive and very annoying. And the speaker turned to the person next to him and said, do you mind just, stirring him up a bit to get him to stop snoring? And the guy shot back at the speaker, you put him to sleep, you wake him up. Okay? So I'm hoping that won't happen here this afternoon. Let me tell you a little bit about this topic, which pulls together different streams in international law and in human rights law. Just about a year ago, I can't remember the precise date, but it was in October of 2015, the Grand Chamber of the European Court of Human Rights, which is a 17-judge formation, in a very controversial decision filed against Switzerland. The case is called Perenchek versus Switzerland. Some of you will know it. And Perenchek is a Turkish provocateur who goes around different parts of the world to stir up conflicts with the Armenians. And he went to Switzerland, where they have a law on denial of genocide, as many countries do now. There are European directives on this. They have a law that makes it an offense to deny a genocide without specifying. And so he went there and contested whether genocide had taken place in the Ottoman Empire in 1915. The Armenian community complained, he was prosecuted, he was convicted, and he made an application to the European Court of Human Rights under Article 10, freedom of expression. And the decision at the chamber, the first level at the European Court of 7 judges, was, as I recall, 4-3 in favor of the applicant. So he won. The European court said that the Turkish law, as it was applied in that case, was a violation of freedom of expression. And then it went, at the demand of Switzerland, to the Grand Chamber, the 17 judges. And so the ruling was, again, similar, quite divided. The court was quite divided. I think it was 11 in favor of the applicant and 7 opposed. So this is close when you consider that the judges at the European Court of Human Rights in the Grand Chamber are selected to a large extent by, their names are pulled out of a hat from the 47 judges. So when you have a close decision like that, you say, no, if they just pulled another name out, the result might have been different. Well, be that as it may. The judgment's very interesting, and in the main judgment, the majority judgment, they talk about a number of things that they say suggest that this isn't such an earth-shaking. It's not like denying, for example, the Holocaust of the Second World War, to quarrel with the Armenians about whether or not they were victims of genocide in 1915. And there's a section in the judgment that it's called the time factor, where it's a few paragraphs and where the judges of the European Court say, you know, this happened a long time ago. And as time goes by, you know, these things are not, you know, they can't be quite as important as they once were. And, you know, put colloquially, they're saying to the Armenians, okay, so maybe you were victims of genocide, but that was 100 years ago. Get over it. And in the dissenting opinion, the dissenting judges, of course, pick up on this and challenge it. And they say in their opinion at one point, well, why would the time factor be relevant? We don't allow statutory limitation for crimes of genocide and crimes against humanity. And so that's kind of my starting point in the talk. It's that comment by the dissenting judges in the Parenchik decision. Let me just say a few words about statutory limitation, because it's something that a lot of us aren't really familiar with. I think in the laws here in this country, with maybe a few exceptions, and I'm not a specialist. I'm sure there are people here who could answer this in the room, but I wouldn't be one. But in most common law jurisdictions, we have very little statutory limitation. It's not part of a common law culture in a way, so that while you might have a statutory limitation on some minor offenses of 5 years or something for a serious crime, we wouldn't be used to it. In Europe, if you go to continental, I mean, we are still in Europe, I should say, we're in Europe, but on the continent, in France or Belgium or Germany, serious crimes like murder and rape are subject to statutory limitations, 20 years, 30 years. They're time barred. And if you can go 30 years without being caught, then they can't prosecute you anymore. And that's well accepted. I think it comes from the Napoleonic Code. And so it's an important part of legal systems in many countries. In the 1960s, it became clear that a lot of the war criminals from the Second World War were getting close to the sell-by date, to the statutory limitation date, and that they would escape prosecution. And so there was a campaign in Europe to change these laws dealing with statutory limitation. And that led to, amongst other things, some international treaties. Well, there's a UN treaty that's adopted in the late 1960s that says that there's no statutory limitation for war crimes, crimes against humanity, and genocide. And there's one in the Council of Europe as well. So we have this international legal framework, and many countries then have enacted legislation accordingly. I don't believe that there's been any such legislation enacted here because it's not an issue. We don't have a statutory limitation for murder, so it wouldn't be necessary. But in France and Germany and elsewhere, they did that so that they could preserve the fact that they could prosecute war criminals from the Second World War. And they continue to do it. This year in Germany, they're still prosecuting men in their 90s now. The last one, I think Demjanjuk, was wheeled into court on a stretcher, but they're doing it. And they claim it's important to show that these crimes are never forgotten and never forgiven. So that's an important part of of international law. Yeah, that's the background, because this isn't really about the statutory limitation issue. This is about statutory limitation for the crimes. My talk is really about the issue of the right to truth, and whether the right to truth can be also affected by the passage of time, the issue that happened in a way in the Parenchek case. Well, the right to truth as a fundamental human right, we don't find it in the Universal Declaration of Human Rights of 1948. There's no explicit reference to the right to truth. There's no explicit reference to it in the European Convention on Human Rights adopted in 1950, or in the International Covenant on Civil and Political Rights, the main UN treaty where one might expect to find it, that was adopted in 1966. It's an idea, it's a formulation, the right to truth, that starts being expressed in the 1980s. I think it starts actually in the Inter-American human rights system. So we have a reference in a report of the Inter-American Commission on Human Rights. They still have a commission in the Western Hemisphere. The Inter-American Commission on Human Rights speaks at one point about a right to truth of the people with respect to historic human rights violations. And there they were talking about things that were fairly recent in Latin America. Some of the atrocities that were perpetrated in the 1970s and the early 1980s. And then that sort of resonated elsewhere, and it got picked up, and there were references to the right to truth in the case law of the European Court of Human Rights. Really, where the right starts being developed in a more formal sense is in the United Nations. In the United Nations in the 1990s, we have a couple of, well, we have an individual known as, it's a kind of a position within the human rights structure of the United Nations that we call a special rapporteur. And we have a special rapporteur who is dealing with issues of accountability, of criminal accountability. And his name is Luiz Rana. He's from France, and he prepares a series of guidelines or principles on accountability and justice. It's one of the sort of key points in the beginning of what today we call the transitional justice movement as well. So Joanne's report and his principles, I think, date from 1997. And in there, he says in the first of the principles that the victims have a right to truth, okay? Individual victims of a disappearance or of some other violation, that they have a right to know the truth about what happened. But he also talks about it being having a collective dimension, that it's a people's right to truth about the past, that we have a right to know the truth about the past. And his report is kind of reconfigured a little bit, revised about a decade later by another special rapporteur called Diane, or a special expert she was called at the time, Diane Orentler, an American law professor. And she added anything significant on that part. She just basically reaffirmed this idea of an individual right to know the truth about victimization. This is important, particularly for victims of families of the disappeared, to know what happened, but also this idea of the collective right to know the truth. And still more recently, we have within the United Nations in 2011, the Human Rights Council appoints a special rapporteur to deal with the truth. Actually, his title is a little longer because truth, justice, accountability. People say they didn't want to call him the special rapporteur on transitional justice, so they use all these other terms. But the first of them in his mandate is the special rapporteur on truth. And so he's a special rapporteurs, for those of you who aren't so familiar with the UN system. They're independent experts. They often tend to be academics or human rights activists, lawyers, diplomats, who are given a mandate, and then they're independent. And they write their own reports. They typically have a mandate that's for 3 years, and then it's, again, typically, there are exceptions, extended for another 3 years. So they appointed a guy named Pablo de Grief, who's from Colombia, I think, and Pablo de Grief's reports have been issued now since 2012. He went to, he's done a number of missions. So special rapporteurs do missions to different places. So about 3 years ago, he did a mission to Spain. And he was going there to look at issues of and justice and accountability with respect to the Spanish Civil War. And he wrote a report on it. He interviewed people, and there's sort of a ferment. It's not a huge issue in Spain, but there's sort of an ongoing sort of low-level buzz in Spain about the atrocities of the Spanish Civil War. So we're talking 1936 to 1939. Those are the dates of the Spanish Civil War. We had it in the papers just a few days ago because Boris Johnson has just discovered the Spanish Civil War, and he was talking about Guernica and so on. So, you know, it's true that Guernica, they showed the Picasso's picture that was done. That's about the Spanish Civil War, and it's a you know, an important legal, has a legal significance as well. So Pablo de Grief does a report on the Spanish Civil War, talking about you know, disappeared people who were disappeared. They want to know where the bodies are and so on. Is there still a legal dispute there in Spain about the aftermath of the Spanish Civil War? There are also some issues, of course, about subsequent to the end of the war, when the fascist ruler Franco takes over, and then a whole lot of atrocities were committed under his rule, which lasts until 1975. Well, I met with de Grief's researcher, his assistant, shortly after the report came out. And I said, this is really interesting. I said, I like the report. I don't want you to misunderstand my question when I ask you this, but do you have jurisdiction to deal with this? He said, well, what do you mean? I said, well, you're a special rapporteur for the United Nations, and the United Nations is created in 1945. Well, really 46. The charter's adopted in 45, and it enters into force in 45. But the actual institutions of the UN start in January of 1946. And I said, do you have, as a special rapporteur, can you go and look at that? I mean, I'm thinking, because we have a lot of special rapporteurs, we have one on torture. I think if the special rapporteur on torture said, you know, I'm going to open a file now on torture by the British in Ireland in 1917, you'd hear a little bit of noise from the Foreign and Commonwealth Office and from the British government. Say, the UN rapporteur can't go back in history that far back. But he did it. And the Spanish didn't object, which maybe they could have, but they didn't. And so I said, you know, I'm not criticizing you for doing it, but I'm intrigued that you can go back and look at things before the UN is created, because it's not obvious. And he said, I see your point. And I said, so you could do that. Could you go back further? He said, what do you mean? I said, well, if you can go back 10 years before the UN's created, could you go back 30 years before the UN's created? He said, I guess. I said, you mean you could look at the Armenian genocide of 1915? He said, I suppose so. I said, and then could you look at the killings that took place in Paris in 1871, in Paris in 1871. It's not well known, but when the Paris Commune was suppressed, there were, we think, 5, 10, 15,000 people who were summarily executed in the streets of Paris in the space of about 3 days. Could you do that? He said, I guess. Could you look at the Paris Commune, at the Irish famine of the late 1840s? He said, I suppose. Could you look at the St. Bartholomew's Day Massacre? Anyone know when that is? St. Barth? 15, you're in the right century. 72, okay? Massacre of Protestants in France in the late 16th century. He said, I guess. So I said, so where does it end? So it doesn't really end anywhere. So, but I can't believe that the Human Rights Council thought that they were going to appoint someone who was going to be looking at ancient history. Spain's a particular case, of course. It's very recent. But it does raise questions about how far back these mandates can go. And obviously, the position of the special rapporteur is there is no statutory limitation. I can go back as long as I want, really, although this is the only time he's done it. He's not making a habit of it. And and I guess the Spanish were kind of accepted it, but there'd be some countries who would just howl in outrage if you tried to do it. We have some other manifestations of dealing with past crimes. We have it in the declarations of the UN Congresses on Racism and Xenophobia, where they talk about the slave trade and so on. But where I think it gets the most interesting is at the European Court of Human Rights and a little bit at the International Court of Justice. Because there, and you could see from my reference to the judgment in Parenchek, despite the fact that we don't acknowledge statutory limitations for these crimes, we say they aren't time barred. We can go back and look in the past, and we should do this. And it seems to be part of the logic of the right to truth as well. Why would you have some cutoff date if the right to truth is important for a society and for victims? What does it matter that it's 1990 or 1970 or 1936 or 1871? If it's important to the society, then that right to truth exists. But we get some contradictory signals as well. And the main one is from the European Court of Human Rights. So there's a case there, again, quite recent. It's 3 years old, that decision. And it's one that I was very familiar with because I was counsel to one of the parties in the case. This is the case. The name of it is Janovic. I'm not going to start writing on the board, but you can figure this out. It's a case dealing with the Katyn massacre. Katyn, K-A-T-Y-N. Anyone know when the Katyn massacre took place? 40, exactly. We know that now, but it was in dispute. Katyn was a massacre that took place that was committed by the Soviets. And the victims were Polish officers, members of the Polish military. What had happened was that in 1939, at the outbreak of the Second World War, there had been a deal that had been made a few weeks earlier between the Soviets and the Germans about dividing up Poland. I won't go into all the details about what that involved. The result of it was that the Germans began the war by invading Poland at the beginning of September 1939. They took half of Poland and stopped. And about 3 weeks later, the Soviet armies moved in and took the other half. The Soviet view was, this had been our territory before the First World War, we're going to take it back. So their plan was to annex the territory. And they took as prisoners 20,000 officers in the Polish army on the premise that they were going to be politically subversive and opposed to their plans to annex Poland into the territory of the Soviet Union. And these men were held in camps where they wrote letters to their families until about April of 1940. And then the correspondence stopped and nothing further was heard of them. The following year, in June of 1941, the Nazis invade, the German armies invade the Soviet Union. So they cross the border, they take the rest of Poland, they go deep into the Soviet Union. Again, every once in a while, someone says, well, what happened to the Polish officers? At some point, a Polish representative asked Stalin, says, what happens to them? He says, I don't know. The Germans, invaded, and we don't know what happened to them. That was his answer. In 1943, early 1943, a German military unit finds a mass grave at a town called Katyn. In fact, there were a few other mass graves. They find a mass grave there, and they start to, they dig it up, and they find these Polish officers. They set up a commission of inquiry. They bring in forensic pathologists from around German-occupied, Nazi-occupied territories in Europe, and they get someone from Switzerland, from the University of Geneva as well. The Red Cross refused to participate. They invite them. The International Committee of the Red Cross says, we want nothing to do with this. And so they go and they do a very superficial kind of an examination. They find some documents on the bodies of the men dating to April of 1940. And they say, well, that proves that's the time of death. Of course, people learn about this. They say maybe they planted documents. Clear that because you have a document from April of 1940, it means that you were killed in April of 1940. they have contradictory forensic evidence, but the propaganda apparatus of the Nazi government then goes to work on this, saying, you say we commit atrocities, look at the Soviets, look at the terrible stuff they're doing. And the Soviets answer them, and in the West, nobody quite knows what to make of it. Here in Britain, in the United States, because everyone realizes that actually, whether it's the Soviets or the Germans, they're actually both capable of doing this. Okay? Within a few months, the Soviet armies, they're on the move westward, so they advance and they take over the territory, and they have their own inquiry that concludes, of course, that the Germans did it, and that the killing took place in late 1941 rather than in mid-1940. And that's where it remains until 2 years later when they start organizing the Nuremberg trials. And the Russians come and say, we've got to charge the Germans with the Captain Massacre. And well, there's a long story about that. I'm not going to go into the details, although I've written something on this, and I can happily share the PDF of it with anybody who's interested, how the issue was dealt with in Nuremberg. The long and the short of it is, the Nuremberg judgment, after they hear 2 days of evidence and they have the reports and everything, is silent on the subject. It's clear the judges don't think that the case has been made that the Germans did it. At the same time, they realize that they have to be pretty careful how they write this up, because if they exonerate the Germans, this is one of those unusual crimes where there are only 2 suspects. There can't be a third. There's no other possibility. It had to be either the Russians or the Germans. So they're just silent. And the debate goes on. If you'd asked somebody here in 1960 or 1970 or 1980 who was responsible, a lot of people would say, well, it's not clear. The Germans, the Russians, nobody really knows. And of course, Polish people would say, we know that it's the Russians who did it. But lots of people would have said, it's the fog of war. We still don't know. Until 1990, the Russians admit it. Okay, Boris Yeltsin says, we did it. It was a secret that was sort of closely held in the Russian leadership. And as the Soviet Union is disintegrating, they finally own up to it. And since then, they've made some apologies. They built some memorials. There's a whole complicated story about how Katyn was dealt with since 1990. But they don't give up all the documents. They don't give up everything. And some Polish victims, members of the family, try to get them, go to court to get them. In the I think around 2009, 2010, they filed the applications to get the documents, and they invoke the right to truth. Okay. They invoke the right to truth, and they invoke it with regard to an evolving case law at the European Court of Human Rights. So I'm going to park that point for a minute and tell you how that case law has evolved now over the last decade or two. The European Court of Human Rights has, of course, the European Convention jurisdiction over the right to life and the prohibition of torture and inhuman or degrading treatment or punishment. So that the killings in Katyn clearly would fall within the scope of the European Court of Human Rights, except they took place in 1940, and the European Convention on Human Rights is adopted in 1950 and enters into force in 1953 and enters into force for Russia, I think, in 1998. So that's our little problem. We're talking about a violation, and nobody has suggested that you could go to the European Court of Human Rights against Russia for the killings. They took place long ago, long before the European Court of Human Rights had jurisdiction over Russia. And that's beyond dispute, I think, at this point. But about a decade ago, the European Court of Human Rights, well, even before that, the court started developing the notion that the right to life, Article 2, and the prohibition of torture and inhuman or degrading treatment or punishment had a procedural dimension. And this starts actually with the first right to life cases, the McCann case in the 1990s, and then it's been subsequently recognized in a whole raft of cases, the European Court, that there's a right, even if the state can't be held responsible for the killing and for the torture, that the state has a duty to prosecute eventually if they can do it. And so this is called the procedural obligation. The two of them were linked. The procedural obligation was obviously linked to the substantive violation until 2009, when the European Court of Human Rights has a case where the killing took place before the entry into force of the convention, but they recognized the procedural obligation. And this is a case dealing with Slovenia, and it has nothing to do with war crimes or atrocities. It's about medical malpractice. It's about someone who dies as a result of medical malpractice, and the death takes place a year before the European Convention of Human Rights enters into force for Slovenia. After he dies, there's an inquiry that begins before the European Convention on Human Rights enters into force for Slovenia, but that continues after. And so there's an application by the family about the procedural obligation, the right to know the truth, because the state didn't kill the person, it's a doctor who did it. So they're not saying the state killed them. It's not the state that violated the right to life, but they're saying the state has an obligation to do a proper inquiry and they haven't done it. And the European Court of Human Rights says, yes, the procedural obligation is autonomous. It exists even if we can't nail the substantive obligation because it took place before the entry into force for the convention. And so they say, yes, we have jurisdiction over this case with regard to the procedural obligation, and they find that there's a violation. They say when it's closely connected in time, that would be where they would make the exception. And they say, but there'll be other cases that may involve fundamental values of the convention, and there, yes, we could make an exception in those cases as well. And that became known immediately as the humanitarian exception. The idea was there was a humanitarian exception so that even if the killings took place before the entry into force of the convention, that the court could recognize the procedural obligation with regard to the violation, with regard to the investigation and so on for that killing. That's the theory. It's in a malpractice case, but obviously it opens the door to the victims of Katyn. And so they go to the European Court of Human Rights and say, Russia won't give us all the documents. The Russians haven't given up all the information. They've admitted it. They've given some of the information, but their position is we don't have to give it all because these are matters of national security. Okay? 1940, killings in 1940, national security, but that's their excuse. And in that case then, at both levels, at the chamber and at the grand chamber, the European Court of Human Rights says no, that the applicants lose the case. They don't have a right to truth dealing with the massacre. I was involved in the case as counsel for Poland. So I wasn't there. The applicants were individuals. They were family members, children of the victims at Katyn. Incidentally, one of the famous children of the victims of Katyn died just a few days ago, Wajda, the filmmaker in Poland, who made a fantastic film about the Katyn massacre. And I think he passed away the day before yesterday. So they were the applicants. Russia was the respondent. But because the European Convention on Human Rights allows for the state of nationality of the applicant to participate in a case, Poland had the right to intervene. So it's a secondary role in the proceedings. Instead of getting half an hour to argue before the Grand Chamber, you get 15 minutes to argue in the Grand Chamber. And Poland asked me to be the counsel, so I acted for Poland in the case. And Poland was only interested, there were a number of other issues, but Poland was really only interested in this issue of the right to truth with respect to the massacre. We pitched the argument by saying, yes, this was an exceptional case. We spoke to them about Nuremberg and we said, you know, this was left kind of unresolved by the Nuremberg judgment. And the Nuremberg Tribunal was the first great European tribunal dealing with human rights violations, and you're the second one. So you have to tidy up what Nuremberg left unresolved. We were very conscious of the danger or of the problem that the judges there would be thinking, you know, if we open the door to this one, 1940, then we're going to have the Spanish Civil War. And then we're going to have the Armenian genocide. And then we're going to have the Paris Commune and the Irish famine. And they wouldn't know, they didn't know how to draw the line. And unfortunately, we weren't able to convince them that this was an exception that justified that humanitarian clause. So what they did was they said, actually, there is a limit in time. They don't call it a statutory limitation, although the dissenting judges raised the point that it's like a statutory limitation. But they say, actually, the procedural obligation stops on the day that the European Convention on Human Rights is adopted, which is the 4th of November, 1950. And they say, we can't deal with any procedural obligation that results from a substantive violation of the right to life, that is a death that took place before the 4th of November, 1950. Now, it has a, you know, there's something kind of a bit arbitrary about it. I guess it always is when you pick a cutoff date. The European Convention didn't enter into force until 1953, so why wouldn't it be 1953? You know, well, that's the date it was adopted in Rome in 1950. But the convention says that it's there to give effect, this is in the preamble, to some of the rights in the Universal Declaration of Human Rights. So why wouldn't it be the 10th of December 1948 when the Universal Declaration of Human Rights is adopted? Be that as it may, we can quarrel with the logic of it. The fact is they shut the door on the past. And I think this is intriguing, if only because we have these movements going in the other direction within the UN, the Special Rapporteur, resolutions of the Human Rights Council about the right to truth, the idea that we go back in time. And what's the point of having a right to truth if you can't go back in time? That's the whole point of it. It's about the past. But they have this rather arbitrary limit on it. And we have something similar that we get in the judgment in the Parenchik case, where they say 100 years ago, that's past, get over it. And incidentally, the judges say, would you say this to the Jews as well? Would you say that, are you going to say to them in 20 years, the Holocaust, that's a long time ago now. Now let's move on. You know, that's ancient history. But they don't persuade them. We have one other manifestation of this. It's not quite as direct, it's not quite as obvious, but it's the same kind of reluctance of international legal institutions to let these doors to the past be pried open. This is the International Court of Justice, also a case that I was involved in as counsel, where the Genocide Convention was being applied. The Genocide Convention was adopted in 1948 by the United Nations General Assembly. It entered into force in 1951. The Genocide Convention doesn't say whether it applies retroactively or not. There's a general presumption in international law that's codified in the Vienna Convention on the Law of Treaties that treaties don't apply retroactively. By the way, that's the basis of the European Court, saying that they're not going to look at a killing that takes place before the convention has entered into force for a state. But it's subject to exceptions. And particularly in the area of international criminal law, we have exceptions. The Charter of the International Military Tribunal, the Nuremberg Tribunal, that's a treaty. It was adopted in August of 1945, and it only applies to the past. It's about trying people for crimes committed in the past. So there's nothing in principle wrong with it, and one might say, well, these treaties are of a nature that they should apply to the past. And I've always thought that about the Genocide Convention. It actually says it in the Genocide Convention. In the preamble, it says that whereas genocide has been committed at all stages of human history. So why not have it apply to the past? Of course, some of that argument has already been made here in the UK. Some years ago, the barrister Geoffrey Robertson did a report for the Armenian community about the genocide of the Armenians and the legal issues involved. There were parliamentary questions about it, and the position of the Foreign Office, the minister, the answer was, oh, we can't call it genocide in 1915 because the Genocide Convention doesn't apply retroactively. Okay. Now, it hadn't been decided whether the Genocide Convention applies retroactively at that point. And in a way, it didn't matter because we're talking about the word. Geoffrey Robertson wasn't saying the convention applied to 1915. He's saying it was genocide. The position of the Foreign and Commonwealth Office is we don't use the word because it doesn't apply retroactively, the word. Kind of like, you know, smallpox. We don't use the word smallpox to refer to diseases caught in the 18th century because we hadn't discovered the germ of smallpox or something. So that's the position. It's kind of inconsistent anyway because there was a resolution of the General Assembly that recognized genocide in 1946. So 1948, the British voted in favor of that. So that couldn't be the date either. And in 1915, when the Armenian genocide was taking place, the British and the French and the Russians issued a statement where they spoke about these new crimes of Turkey against humanity and civilization. So they didn't use the word genocide. It hadn't been invented yet, but they used the term crimes against humanity. If I'd been in Parliament then, I would have said, I have a little follow-up question. You don't want to use the word genocide, but do you agree with what you said in 1915, that it was crimes against humanity? We all know the reason. They don't want to, because they don't want to get Turkey pissed off. That's really the only reason why they do it. Well, the question of whether the Genocide Convention could apply retroactively had been left unresolved by the International Court of Justice, the main legal forum for interpreting the Genocide Convention. And it had been expressly reserved, actually, in an interlocutory decision by the International Court of Justice in, I think, 2008. But in the case, again, decided last year, 2015, in February, in the case of Croatia versus Serbia, the International Court of Justice said very explicitly, there's no retroactive application of the Genocide Convention. And I was a bit disappointed with that, not because that was the argument that the side I was representing put forward. In fact, the side I was representing was putting forward the opposite argument. But of course, I was a good lawyer and I had to argue their case. I didn't have to argue that part of it, fortunately. But my heart was always with the idea that the Genocide Convention should apply retroactively. But they've closed the door on that as well. So all of this is to say that there's sort of these contradictory trends at work. There's this drive for the past, to the truth, to know the truth about the past. It flows from human rights law. It's being increasingly recognized by bodies like the Human Rights Council, the special rapporteurs, and so on. But there's a resistance to it as well. I think in some ways we enter the realm of philosophy. We get away from law a little bit here. And I have, and I'll conclude with this, sort of a theory about it. I think there are things in the distant past, and I give, my somewhat facetious example when I say, does this cover the Irish famine or the St. Bartholomew's Day massacre, or we could go back even further. Nobody really cares about that. I'm not saying people don't care about the massacres or about the Irish famine, but the issue of temporal jurisdiction, and it's not really going to get anybody's blood boiling. They'll say, well, of course historians have to look at all of this. It seems that there's a period in the past where this gets very sensitive. And then at a certain point, we go further back and it doesn't seem to matter anymore. To that extent, I think in a way, the European Court of Human Rights was onto something when they talked about the time factor. I think there is a time factor. And maybe for the Armenians, we haven't yet got to that threshold. And there would be other groups as well. Probably it's related to the fact that they associate a situation today of violation and oppression with something that happened in the past. So that's important to them. But if that's not there, who cares about something that happened 150 years ago? Or rather, who's going to argue about whether we should have a right to know the truth about it? People say, well, of course, we should have that. We should have the archives should be open and we should have all of that. It seems there's a period, as I say, the European court says, don't look back before 1950. And there are a few traces in the case law, actually, in the first decision in the Captain case. The Russian judge says, let's not open that dark chapter in European history. It's this idea that, you know, after the Second World War, we adopt the Universal Declaration of Human Rights and the European Convention, and we turn a page. So let's not go there. Let's not go and pry into the past. And yet, nobody, as I say, would object if we wanted to pry into the past of the 19th century. I think it has something to do with human longevity. It's because we can still relate to this. I have Armenian friends who knew their grandparents, who were victims of the genocide in 1915. And so it's real for them to that extent. It's more remote. We're talking grandparents or great-grandparents. It's more remote. And at some point, it just grows cold, I suppose. So again, to go back to my point about statutory limitation, we don't have statutory limitation generally for serious crimes. But sometimes I think prosecutors look at an ancient crime and say, that was a long time ago. Let's move on. Let's focus on other things. Sometimes we don't let go. So we don't do it today with sexual and gender-based crimes. But that's because we're concerned about today as much as with the past. So I wonder if that's at work as well. So this is, as you can see, it's kind of a work in progress about the right to truth and where it's going, and whether this reluctance of some tribunals like the European Court to allow that right to sort of to blossom and to be properly implemented is going to, whether that's going to change. It doesn't look good at this point. On the bright side, one can say they've made it clear that they can look at everything that happened in the Soviet Union and Eastern Europe since 1950. So even though the countries of Eastern and Central Europe didn't join the Council of Europe until the mid-1990s. So that's a big piece of it. But going back further, no. And so that's where we are, and I'm going to conclude there. I'd be happy to take any questions you have. Thank you.
Excellent. Thank you very much for, I think intriguing is the word. I'm a little, I guess I'm thinking, is this a philosophical issue, a historical issue? We need more historians, fewer judges. So many questions running through my head right now, and I'm not going to try and start the questions. So the floor is open. I'd say there is one man sitting directly in front of me who must have a question.
I actually do.
I knew you would. I'm not picking on you, but I can sense you welling up the question.
I'm always a little dubious in a way about this right to truth. I sometimes feel it's the product of a very modish language from the 90s, like the Diane principles were 1997, and of course the language of truth came from the Chilean and South African truth commissions as well. But when you break it down, and even if you look at all the examples that you talked to, they're kind of a right to truth, but they're all actually more specifically something else. Like we talk about McCann, Velasquez, Rodriguez, you're not really so much talking about a right to truth as a right to specific, very precise, almost forensic information about a specific thing that happened in the past. Peronich is more a right to non-denial. It's not really a right to truth. It's a right for a community to not have something denied to them. The issue with Spain and what happened in the Civil War is more a right to clarification. I mean, you narrow the group of facts that people will disagree about, but they're still going to disagree about it. And maybe Kachin is much the same. Truth and Reconciliation Commissions, of course, you were involved in one. We discussed that under the right to truth, but that's more sort of almost a right to it becomes almost a right to a shared history that people have, or even Kachin. You could consider it a right to vindication, an ongoing reestablishment of the fact that happened. And I do wonder, like, the whole concept of truth is loaded with like metaphysics and morals, and I do wonder, does it become too emotive a word perhaps to describe what are actually sometimes very different debates that are going on. The other thing I was going to ask, that's more a point actually, I don't think there's a question, but I'm just inviting you to discuss it. The other question I would have,
You could just say, what do you think? At the end,
yeah,
say,
probably should have. The other thing is a question that I do wonder, is this, because I was at a conference once on the first Armenian genocide, which is 1896, the genocide even the Armenians themselves sometimes manage to forget that being lived. But there was historians there, and they found the idea of judicially arbitrating on these issues to be like utterly laughable. So I wonder, is this an example of sort of legal aggrandizement? Because I do know that historians would find the notion of legal institutions having any hand, act, or part in this to be dubious.
Yeah, oh, they definitely do. Yeah. Yeah, I mean, I didn't really attempt today to explore these dimensions of what the truth is. And sometimes we're arguing, the Armenians, for example, they think they know the truth. They're not looking for the truth. They know the truth. They just don't want anyone disagreeing with the truth. And so they generally, although even amongst the Armenians, there's some division because a lot of them are appreciative enough of freedom of expression that they say, well, look, so he wants to deny it, but can he say that? Yeah, he can. And that's more or less my view of things. I don't really, I think it's a pretty blunt instrument trying to deal with these issues. You know, sometimes the denial of historical fact, this is how it evolved in Germany. The denial of the Holocaust simply became a coded message for anti-Semitism in Germany in the 1960s because everything else was prohibited very strictly by law. And so the deniers started saying, or the racists and the anti-Semites in Germany started to say, okay, I'm not going to say anything anti-Semitic, but I think you're exaggerating about the number of people who died in Auschwitz and that kind of thing. And so then we're maybe into a different field, but there we're not arguing about the past. I think the Poles know what happened in Katyn as well. So we talk about it being a right to the truth when in fact we often know what the truth is. I think with people who've been disappeared, the individual right, and this is it's the only treaty where we explicitly acknowledge a right to truth. It's in the Convention on Forced Disappearance, and there at the individual level, it's recognized that you have there's some human right to know what happened to the body of your loved one. People are very attached to that. But when we move into this more collective right about the truth, as I say, and maybe that's why no one's overly excited about the Irish famine or about the St. Bartholomew's Day massacre, because we figure we kind of know what happened, and we're not going to, or maybe we quarrel about it. We realize that no one can win the argument. Nobody really, that there are different theories, and that's it. So that I just add that to the discussion. I agree with you. It's an odd, nebulous kind of a concept that generally has to be hitched to some other fundamental right somewhere. It doesn't seem to work very well autonomously.
Can I ask a follow-up question? Well, it's more of a comment to disagree a bit with Padraig, because yes, it attaches to something technical all of the time, but actually it's that esoteric, untouchable part of the right to truth that we can't quite describe, that often seems to be at issue. And I wonder if it's something to do with not the right to truth, but so much as getting the right to an admission of wrong, in a sense, by whoever the wrongdoer was. And I think of that in relation to the Marmouth cases in Britain, where yes, they're seeking something very practical, which is compensation, but that's very much attached to something non-technical, and it's that non-technical thing that seems that you're intrigued by, to me.
Yes, of course, but it's very difficult to tease that out as well, because we encounter this, and as I say, pardon me for focusing a lot on the Armenians, but it's a debate I know well. I've been to Turkey, I've been to Armenia frequently, and so I'm immersed in that that debate. And but we could pick on other examples there. If you go to the Turks and say, couldn't you just apologize, kind of like what, everybody's apologized. Didn't Blair apologize for some things? And Bush apologize. I mean, lots of people just say apologize and we'll move on. And the Turks say, yeah, but if we apologize, then how much do we have to pay? Oh, no, you don't have to pay. They've agreed you don't have to pay. Yeah, that's what they say now. But then we'll apologize and they'll say, you owe us money. And the more extreme Armenians, not only do they want money and property restored, but some of them say, and there are those 2 provinces in Turkey that belong to us. So, you know, we're talking World War III when we start taking provinces away from Turkey and giving them to Armenia. So, I mean, this is also the problem with the acknowledgement. We've had that issue with slavery and the slave trade and colonialism. And saying, well, if you apologize, maybe that won't be good enough. And maybe we'll wait 10 years and then they'll come back saying, give us back. You know, can you imagine if we had to give back what was stolen during the slave trade? I mean, I think Oxford University would have to shut down probably, and Brussels would have to, you know, disband as a city. And I mean, that's the problem with it as well. So we don't know the repercussions, and I dare say we'll come back 20 years from now and the debate will have shifted, because these topics were unthinkable 20 years ago, and now they are. And, you know, the hard part is to see exactly what direction it's moving in. I don't know.
Okay, more questions? Thoughts, comments?
Well, I just had a couple of pretty specific questions. There's just 2 things that sounded strange to me, and I'd like to know more factual detail. Spain was the first report by the special rapporteur, but he has to be, you know, invited by the government or allowed to come. Seems strange that Spain, with a historical sort of tendency of not wanting to sort of delve too much back in the past, would actually allow him to go and given that they have the clear choice to say no, and make a report on Spain. So I was wondering if you had any more information about why Spain would have allowed him to come. And then secondly, the ICRC not participating in the investigation in Katyn at the time. Why did the ICRC not participate?
Yes, well, I'll do with the first one first. The International Committee of the Red Cross said they were asked to participate, and they just said, look, this is a Nazi organized commission of inquiry. We don't do that. We're not going to go. They were concerned about their reputation for neutrality and independence. I think that's the explanation they gave. And a lot of people frowned on the Swiss professor from the University of Geneva actually going in and doing this, because it looks like, you know, today we know the truth and everything about it, but it does look like a bit of a sham as an investigation, and really kind of I don't want to say a cover-up, because they did have the truth, but it was a propaganda exercise by the Nazis. In the account of it, he described, this is the Swiss law professor, he flew out to Katyn and looked at the mass graves and did a little summary autopsy on one of them, and then issued a report. He describes in his, he wrote about it, and describes returning back, and they flew over Warsaw, and he saw a whole lot of smoke and stuff in Warsaw, and he thought that was kind of interesting, and then moved on. Well, what was going on in Warsaw was the liquidation of the Warsaw Ghetto, the same time in 1943. So he found the mass grave with 10,000 bodies there in Katyn, or 15,000 bodies. But he sort of missed the 500,000 people who were being massacred before his very eyes as he flew over it. You know, it was a propaganda exercise. It's just they were actually on to something. You know, your first question about Spain. You know, why did Spain agree that special rapporteurs do need to have the consent? Of course, they go onto the territory of a state, and some states don't allow any special rapporteurs in. Some pick and choose, and so on. Well, I don't know the story about why Spain didn't object. I don't believe they've objected to the report he did either. I don't think that they're self-conscious about their past or anything, that they don't want someone doing it. There's an ongoing conversation in Spain about this, where you have some people, human rights activists, who say we need to get more, we have to have more accountability, more investigation into the atrocities of the Spanish Civil War, and others who say, you know, we settled all that after Franco died. We had an amnesty, and we agreed to move on as a society. Some people don't like the amnesty, and lots of people do and agree with it. And I think when I've talked with Spanish people, I get a mixed message about that. There is more to this more technical issue, if you want, about the temporal jurisdiction of the United Nations than I described. There's a little bit more to it. I don't know if it's enough for a doctoral thesis, but it's enough for a law journal article, certainly. We have his report, of course, of the special rapporteur. Before the special rapporteur and before, you know, on the issue of enforced disappearance, we have the Convention on Enforced Disappearance, and we have a committee, a treaty body of the Convention on Enforced Disappearance. And they've received complaints or applications to them dealing with Spain during the Civil War about enforced disappearance, Spain during the Civil War. And there, the committee, but I think Spain has made objections, but there they have a basis in the treaty. The treaty says it doesn't apply to a disappearance that took place before the entry into force, which I think for Spain is 2007 or 8. And so the treaty body, the committee, has just said, we don't deal with it. We also have a working group on enforced disappearance at the United Nations, which is not based on the treaty, but which has its legal origin in some resolutions of the Commission on Human Rights and then also the Universal Declaration of Human Rights. And they have been in operation, I think, since the 1990s. And they too have received applications dealing with the disappeared during the Spanish Civil War. And initially, they took decisions, so this is on the record, you can find the decisions on the internet or in their reports, in about 2001 or 2002, saying, we can't look at anything that happened before 1945. But they don't explain that in their reports, but it's obvious that that's because that's when the UN starts. They say we can't. So they understood the problem, and that's how they addressed it. Subsequently, they changed it because they said, if someone disappeared during the Spanish Civil War and it was not, we didn't get the truth about it subsequently, as long as, and this is the European Court of Human Rights jurisprudence on the disappearances, the Cyprus case and so on, they say as long as we don't know what happened to the person, the violation is kind of an ongoing violation. And so they've now taken that view. So they will look at the pre-1945 cases to the extent that we don't know whether or not the person died. You know, we just know that they disappeared. You know, it's a pretty strong presumption if you disappeared in 1937 and you haven't been found yet. But so that's how they finessed that a little bit. But so all of this is to say that that question I raised for the special rapporteur actually had already arisen there, and it's in these Spanish Civil War cases.
Please, actually, could we introduce ourselves when we're asking a question, just so I know who's in the room?
Hi, my name is Brian. I'm doing the postgrad in international human rights law. And my question is, usually it is very difficult for states to work towards the protection of or respect for human rights unless there is a legally binding component to it. And the United Nations Office of the High Commission for Human Rights with the Human Rights Council has recognized this specifically with the said right to truth. And because of that, they have come up with this right to truth resolution where they have specifically hinted, like you said, upon the International Convention for the Protection of Persons Against Enforced Disappearances. And within the same resolution, they've actually also called for all states that are not signatory to that convention to be a part of it. Because they also perhaps only recognize that that is the only way they can introduce the language of the right to truth to member states when it's in a legally binding instrument like that. And also in the past, I mean, some of the rights that have come up recently that were not envisaged in those prior conventions, such as the right to the city or the right to development, that the UN has wanted to front, it has done so through other means, for example, the Human Rights in Cities for All. But then this is also because it recognizes that for a right that is just emerging, such as the right to the truth or the right to the city, it will be quite difficult to get member state support behind it, to endorse it as an international legally binding right, and it will take long drawn out periods of time before it actually becomes that. So So they sort of use other strategic measures to endorse that. So I would be quite interested to know, in the best case scenario for the right to the truth, how do you envisage it panning out as sort of a legally binding right that states can be held accountable for? Or do you see it still getting hinged on the protection of persons from enforced disappearances, which is in that specific convention that a lot of member states have ratified?
Yes, well, of course, it's at the European Court of Human Rights, which has recognized the right to truth in several decisions, several judgments, and which recognized it in the Captain case, but only back as far as 1950. There, it's based on a treaty obligation. It's a corollary, if you want, of the procedural obligation in Articles 2 and 3 of the European Convention on Human Rights. So, I mean, that's legally binding. Of course, you know, the European Court is constantly enlarging a little bit its jurisdiction through interpretation. We had a little manifestation of that last week when who was it in the government said that it's outrageous that the European Court thinks that they have jurisdiction over violations in armed conflict that take place outside the territory of the United Kingdom. Yeah, well, there was a bit of a shitstorm about that last week, and yeah, and the big misunderstanding about the European Convention on Human Rights, because they seem to think they can derogate from the right to life. You know, but now I'm digressing. Let me just pick up on another point, though. You know, your observation, you're probably a little more positivistic than I am in your attachment to the treaties. One of the things I'm fascinated by, this is another talk, okay? If I come back, Michelle, I'll do the talk on this, is how what people sometimes call soft law, or the non-treaty part of human rights law, has become increasingly important within the United Nations in the area of human rights. And specifically, the Human Rights Council under the Universal Periodic Review, where states, even in the absence of treaty obligations, report on rights that are found in, well, the resolution on the Universal Periodic Review says it's based on the Universal Declaration of Human Rights, as well as the treaty obligations. They don't generally distinguish very much between they don't come and say, well, we don't have to report on that. We didn't ratify a treaty on this. The resolution setting up the Universal Periodic Review says the basis is the Charter of the UN. It doesn't really say much substantive about human rights. The Universal Declaration of Human Rights, which says a great deal substantively about human rights, and the treaties that bind the state in question. But you get, you know, if you look at the Chinese reports to the Human Rights Council, China's, you know, one of the main states. There aren't many now that haven't ratified the Covenant on Civil and Political Rights. So you'd think they'd say, well, we're not going to talk about the death penalty, and we're not going to talk about slavery, and we're not going to talk about other issues that are covered by the Covenant on Civil and Political Rights, although they're in the Universal Declaration of Human Rights. And the Chinese report as if they've ratified the Covenant on Civil and Political Rights. And the US do the same. They've done the opposite of China. They've ratified the Covenant on Civil and Political Rights, but not the Covenant on Economic, Social, and Cultural Rights. And when they come and do their reports to the Human Rights Council under the Universal Periodic Review, they talk about housing and education and medical care. So it's quite interesting that it's as if they don't make the distinction between the binding obligations and the so-called, quote unquote, non-binding obligations. I think part of that also is because the treaties now, the treaty on the Convention on Enforced Disappearance, I don't know how many, do you know how many states parties they have yet? 50 or something. I mean, they're not close yet to having anywhere near universal acceptance. But the other treaties have got to a point. I mean, when I started working in this field 25 years ago, you'd go and look up on the list to see if the state had ratified the treaties, because most of them hadn't. You know, it was a patchwork of ratification. Today, the vast majority of states have ratified the vast majority of international treaties. So that's something that's changed as well. So we could say maybe now they're doing it because they're treaty obligations, and maybe they just don't care and don't make the distinction. I think the Covenant on Civil and Political Rights is 176 or 177 states parties now. That's out of 193 possibilities. And you have to subtract from that about a dozen very small states, Pacific Island states, a few of the Caribbean states with, you know, populations under 100,000. And they come to the Universal Periodic Review, and, you know, Sweden or Norway or Ireland or someone says, you should ratify the Covenant on Civil and Political Rights. And their answer is, well, we don't disagree with it, but it's an expense. We just don't have the, you know, the means to do it. So they don't disagree in substance either. So when you narrow it down to the states that appear to have a problem with these treaties, you're down to Singapore and Malaysia and China, and depending on the treaty, the United States with the economic and social rights. But it's becoming less and less, I don't, it's not even, that's understating it to say it's less and less significant. It's becoming more and more insignificant.
Before I give the floor back to Josh, any other questions? You can go, but I'm sure there are lots of questions. So let's get a,
Yeah, no,
please.
oh, sorry.
We will come back to you.
No, there's someone else.
Yeah.
Hi, I'm Alex. I'm a year undergrad. So we tend to say that history is written by the victor. Do you think, to an extent, that's true when the court are interpreting history? So, for example, if we're looking at, say, something that's happened on the other side of the world, are we in fact looking at it through a kind of Western lens, should we say?
Maybe. I mean, if you go back to Nuremberg, obviously it's the victors who set up the tribunal, and they're giving their version in a sense, although it's a version that stood the test of time and that is also well accepted by the vanquished, by the German people now, the truth of the Nuremberg judgment. I think maybe with the Tokyo judgment, it's not quite so unanimous. It hasn't had the same basically universal acceptance. They say the Nuremberg judgment initially was not very popular in Germany. It took a generation essentially, and maybe even more than one generation. I was in Nuremberg 2 weeks ago at the courthouse where the trial took place, and now the German government, but it's only recently, the research institute there in the building to commemorate the Nuremberg judgment. So it's like gaining traction and gaining momentum among the vanquished, you know. The other thing is that fewer and fewer of our conflicts today, of our modern conflicts, are international conflicts. They're internal conflicts where it's not so clear whose side you're on even. I mean, we're looking at, you know, this terrible, terrible humanitarian disaster in Syria. But aside from knowing that al-Assad is a bad guy, does anybody really know who's who in that conflict? And you know, and it changes from month to month as well with these shifting alliances. It's very, very difficult even to say who the good guys are and the bad guys in that conflict at this point. I know that the Russians are the bad guys now. They say in their defense, we've saved more lives and more liberated more villages. It's the fog of war, I guess.
More questions? John?
Well, it was just to pick up on your softball point and states. I just wonder whether from a sociological standpoint, the UPR is really interesting because states have sort of started to take seriously this idea of interdependence and indivisibility as a result of a whole lot of collective things, like a plethora of judgments, reading in procedural obligations, or, you know, rights to health within rights to life, etc., over the last 20 years, and states, particularly through the UPR, are starting to not see the lines. They're starting to see a blurred human rights general obligation that as a positive development on whether you
I think in terms of human rights monitoring, enforcement, and so on within the United Nations, it's a success story. I remember a decade ago, because it's 10 years now. It was 2006 when they reformed the United Nations. There were a lot of conferences then at the time of the specialists in the field of human rights, people who were members of the treaty bodies, ambassadors, special rapporteurs, and they would meet at these conferences. I attended some of them, and they were so nervous about this. They said, "Oh, this Universal Periodic Review is going to be a disaster. It's much better in the treaty bodies, where it's much stronger, much more robust, much more independent." And they were really just protecting their little fiefs, I think. Well, there was a great deal of that going on. It's unfortunate. You'd think that the human rights field would be one area where everybody'd be just saying, let's be creative and imaginative. But you have people who they're in the system and they don't want it to change because they're afraid they won't get renominated for one particular committee, so they won't get their badge to get them into the building in Geneva and that kind of stuff. And so there was a lot of negativity about it. And it very quickly, during the first years of the Universal Periodic Review, it began in 2008, and until I think 2012, I was a member of a board at the Office of the High Commissioner for Human Rights, called the Board of Trustees of the Voluntary Fund for Technical Cooperation. It's not an important mandate. It was a great mandate from the UN, because unlike some mandates where you get denounced in the New York Times and stuff like that, this was a mandate where you had no enemies and everyone loved you because you had money. You were the head of a fund. And so we would go to Geneva I would go there for 2 weeks a year, two sessions of a week. And we'd sit there in the Office of the High Commissioner, and one after another, the various officials within the Office of the High Commissioner would come and meet with us and give us a report on what they were doing. And then we'd write a little report. It was great. I'd love to do it again. It was a great mandate. Low maintenance, very easy. And, we used to have every 6 months, someone would come to report on the team that were helping the Universal Periodic Review in the Human Rights Council. And the first time they came, like in 2007, they said, "Oh, we don't know about this. It's kind of scary. We're kind of nervous about it." And then 2008, they said, actually, it's kind of good. And 2009, they said, it's really surprising us how good it is. 2010, it's fantastic. In 2011, when they were coming to the end of the first cycle, because it takes them 4 years to cycle through all the UN members, they said, now we're nervous because we're going to do another cycle, and how do we do as well in the second cycle as we did in the first? So I'm not saying it's not without its flaws and its shortcomings, but it caught a lot of people by surprise, and it's proven to be extremely good and useful.
I'm very conscious that we've only had male questions. Any females with a question? Otherwise, I'm going to pick on Mike Gordon, who's definitely skeptical of everything that's happened here, as our court skeptic, human rights skeptic. You're not female, so
No, I'm
let's
not
see.
female, so there's a female speaker who'd like to ask a court skeptic question. Or a non-court skeptic question.
Please, and then we will hear.
My name's Jessica. I'm doing the LLM human rights.
I thought so.
In my undergrad, I looked at the Truth and Reconciliation Commission in South Africa, and had loads of great ideas, and then they were all promptly ruined when I actually looked deeper into it. And I kind of feel that, at least from my point of view, that the right to truth is only necessary and only wanted when the people are still alive and people are still, it's very much fresh in people's minds. So with at least with South Africa, Mandela did his walk to freedom in '94. It's still very much within living memory. But with as you said, with the Armenian genocide, it's generational now, 2-3 generations, and I think that, well, my question is, when, you know, we talk about the luxury to truth as a sort of, you know, fabricated like love sort of thing, you deserve the truth, but that sort of thing. But if there's no one to fight, if there's no one to want the truth, does that make it easier? Or if there's only like a small group of people who want the truth, does that make it easier for courts, for politicians to sort of go, well, this truth doesn't matter as much as this truth, or something like that? I don't know.
Well, probably like many people in the room, I've thought, in the context of truth commissions in particular, and that part of it, thought a lot about these issues. As someone mentioned, I was on a truth commission. I was on the Sierra Leone Truth and Reconciliation Commission, which was inspired to a certain extent by the South African Truth Commission. It was meant to provide the people of Sierra Leone with some measure of truth, because there had been a decision taken in the peace agreement not to have any prosecution. So they weren't going to get the truth through criminal trials. And as you know, in the past, they would often not, you'd have an amnesty and that would be the end of it. So the point about truth commissions is that they do provide some measure of truth, and the South African Truth Commission did that for individual victims in many cases. I don't know how much it did for the big truth, which was about the truth of the apartheid regime. I think everybody figured they knew the truth about the apartheid regime. It wasn't a mystery in the same way it was wanting to know what happened to Steve Biko in his last hours or something. And those kinds of things were to some extent brought out by the Truth Commission through this mechanism of getting perpetrators to come and tell the story of what happened. In Sierra Leone, that sort of worked partly. I'll tell you the part of it that interests me in a way the most. I think a lot of these issues about truth and reconciliation and so on are, we can relate to them even if we haven't lived in a place like Sierra Leone in the Civil War or in South Africa under apartheid, because we encounter them in our daily lives and in our interpersonal relations as well. Sometimes the truth sets you free. You know, you have a problem in a relationship with someone, with your family, with your friends, with your loved ones, and you know, you've got to get the truth out to clear the air so that you can move on. And sometimes it's better not to know the truth, you know. I mean, I'm not going to make any confession here tonight, but there are like a few things I've done in my life that I could never tell my mother about, okay? Just never. I don't know if this resonates. Maybe you're all thinking, what a weirdo, you know, I tell my mother everything. But there are some things that I just don't want her to know about. Wouldn't be very happy, and you know, she'll still love me, but wouldn't be good. And in relationships, you know, we once had a friend who thought he'd clear the air by telling his wife the truth about the fact that he'd had an affair. So she, you know, kicked him out of the house for a few days and took all his neckties and cut them in half and stuff, and you know, took revenge in her own way. And then she forgave him, and so the truth, you know, helped to clear the air. Then he told her about the next girlfriend. And it finally, maybe it wasn't a great idea to tell the whole truth, you know, for the relationship. But we do get this also when we're having this tension about deciding how a society moves forward with amnesties and so on. And that I don't think that it's fundamentally offensive to say, maybe sometimes we won't have to know the truth as well. And I think we can understand that from our life experiences. And there's probably a tension between the individuals wanting to know the truth. This is the issue with peace building everywhere. Colombia being the most recent example, where the individual right to justice, to the truth, all of the things that we recognize, the individuals that flow from the human rights treaty, but they get in the way of peace agreements. They become obstacles to peace agreements, and you have to that out in a way that's sufficiently respectful of the victims, but you have to say as well, you know, it's not just about you. You're not driving everything, and you're not the you're not, at some point you have to back off and let us, because society as a whole needs to move on and needs peace. So.
Mike, we have a couple of minutes left. So.
Okay. So I'm a constitutional lawyer, so this may not fit in exactly, but I'm interested in sort of the narratives of rights development and the role of courts and law in that process. I mean, I don't know whether I'd be interested in your thoughts on this. You sort of, for me, what you're explaining here is a sort of narrative that starts with the failures of courts to enforce rights, and I don't mean failures in like a subjective sense that they are bad courts, just that they are institutionally incapable of solving the kind of moral, political, historical problems that we're dealing with here. So then that sort of leads to the move to soft law, constitutional law. I like to call it constitutional conventions, and it takes the idea that it's legally binding at all out of it. But soft law, I know in the international and European realms is the way it goes. And I suppose what I'm interested in then is the effect of that you see a legalization of what are really diplomatic and political processes in structural terms, sort of through the way those problems are approached, and also in personnel terms as well. You talked already about the lawyers guarding their fiefdoms and everything else, which is very interesting. And I suppose when I hear that narrative, I think, well, one, that has a sanitizing and limiting effect on the capacity to resolve these problems. And two, it also turns into a feedback loop as well, because it goes back then and creates the argument for, well, we should solve those problems with courts that caused the thing to start with, that caused this shift onto the diplomatic political territory, which I think is quite problematic because they are institutionally not capable of doing it. So I don't know if you have any views on that.
I'll make a very brief comment, because I think the time is short and I have to be thinking about getting to moving on. But I think, in the area of human rights, most of our lawyering, most of the legal stuff we do has very little to do with courtrooms. We're not in the courtroom. We get there. I've had the great thrill in recent years. I've been now 3 times to the Grand Chamber of the European Court and once to the International Court of Justice. So it's a great thrill. It's interesting. It's important in lawmaking because certain big issues get decided. But most in human rights, most of our legal, our lawyering is outside the courtroom. It's talking to journalists. It's making statements, soft law declarations, UN measures, and so on. So maybe more so, although I don't know. Maybe we can make the analogies, I'm sure, with domestic law and with constitutional law are the same as well. Look, here we have this. I guess there's some court case going on today about Brexit, isn't there? But does it have any hope?
The government's arguments are completely strong, but whether the court decides to do something mischievous is entirely up for grabs. Probably more likely in the Supreme Court.
Yeah.
Neuberger is probably sitting there thinking of some new theory of the rule of law
Okay.
as we speak.
But here is a case where the debates about the law, the binding nature of a referendum, whatever the Constitution is, this mysterious concept, it's all going on outside. Most of it's going on outside the courtroom, and a lot of it by non-specialists.
But a lot of it by lawyers, which is the interesting thing. Anyway, sorry.
Well, there is such a breed as a lawyer who's not a specialist in certain things. So.
A lot of it by male lawyers too. Same thing in this Brexit thing. When I started, I'm a little tired today, so I didn't introduce you 100% in the way that I hoped you, which was to have a little rant about how Professor Schabas has been super inspiring to me and to Josh and to Patrick, who was his Professor Schabas was your internal examiner, am I right? And he today is not in the room, but there were external, exactly. There are a number of people already in the law school who had the privilege of knowing Professor Schabas for a number of years. And one of the things that I've always taken with me from being a student of yours from when I started my master's is the way in which you just generate research, generate a research environment, and generate a curiosity, and this sort of curiosity that you've established today, just an interest in how these legal issues develop and how the politics of human rights develop. And so I have one teeny tiny question. Maybe we seem to be in an era where there's a crisis of human rights. So we hear it all the time. We have it in the UK, and we have in the room a number of students who are doing an LLM in human rights law, a number of students doing PhDs in human rights law. And I just wondered whether you'd any sort of final thought before we let you go on what the future of studying human rights is and working in this area, whether you've any little words of advice for all.
You know, I'll tell you what, stay tuned. In a month, I've been invited to give a TED talk.
Oh!
I'm doing a TED talk in the middle of November, the 11th of November in Zurich. And I propose to talk about human rights 50 years in the future. And so the theme of my talk is going to be, you know, what are the rights? We have certain rights and things that we cherish today as important human rights that were kind of unimaginable 50 years ago. And so the exercise, it's, you know, kind of like 50 years ago. I know none of you can remember that far back, but I can. And if you told me 50 years ago that I'd be walking around with this little piece of metal and plastic in my pocket where someone could telephone me from anywhere in the world, I'd say, where will the wire go? Where will I plug it in? You know, I wouldn't have understood that. It's just unthinkable science fiction. And, you know, so people often do that with technology and say, so what is it going to be 50 years from now? So my exercise is, what will human rights be like 50 years from now? There will be more of them than there are today. It's not going to shrink. It's going to grow.
Thank you, Brian. Thanks to all of you for coming. Our next talk is by Rosa Friedman, sometime in November 23rd, we'll call it. Well, we have now, it's a 47 now. So, it's about a no, we're not in the